Richard.
Jefferson County Code of Law number 2 is in session. The court is in session in its jail review docket on today's date, July 3rd of 2025. First case is cause number 24-CCCR 1284. The case is styled the state of Texas versus Deborah Ann Guillory. Ms. Guillory, is that your full name? Ms. Guillory, would you please raise your right hand? Ms. Guillory, do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Guillory, you may put your hand down. How are you doing, Ms. Guillory? You all right? Ms. Guillory, you're represented by your attorney, Attorney Mark Faggett. Attorney Faggett, how are you doing?
I'm great, Judge. Thank you for asking.
And you're welcome. And Mr. Faggett, do you waive a record in Ms. Guillory's case?
We do.
Ms. Guillory, I have before me the state, who is State Assistant Criminal District Attorney, Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. Thank you.
You're welcome. And Ms. Guillory, I have on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Deborah Ann Guillory, on or about April 14 of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Ms. Guillory, do you understand what you've been charged with?
Sure.
Do you understand what you have been charged with, criminal trespass?
I think so, I mean.
You understand it? You understand it?
Do you understand that you're charged with criminal trespassing?
Yes, it is.
Okay. Now, Ms. Guillory, to this charge, how do you plead? Guilty, not guilty, or no contest?
No content.
No contest. Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not want to fight or contest the charges?
Yes, sir.
Okay, now, Ms. Guillory, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
I didn't vote.
Yeah, you just wrote it, right. On page 2 of this same document, there's a set of initials. Did you place your initials on this document?
I said no content voted.
Okay, that's what it means, no contest.
No.
Okay, now, Ms. Guillory, I also have before me on page 3 a signature. Is this your signature?
Yes, sir.
All right. Also on the next page, Ms. Guillory, this is a document that is titled misdemeanor, that's titled trial court certification of defendant's right of appeal. Is this your signature on this document?
Yes, sir.
Now, at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? You understand that? Okay. Now, I have another document. I also have another document on paper that is titled Discovery Certification. And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Ms. Guillory, before you sign and initial all of these documents that I just showed you, did your attorney, Mr. Faggett, go over these documents with you? And did you understand everything that Mr. Faggett went over? And is everything in these documents true and correct to the best of your knowledge? Ms. Guillory, are you a citizen of the United States? State?
Jefferson State's one.
Any objections?
None.
No objections. States exhibit number 1 will be admitted. And Mr. Faggett, you advised and counsel Ms. Guillory, is there any evidence that she's currently mentally incompetent to stand trial?
No, Your Honor, she does have some mental health issues, but she was recently found to be competent to stand trial by Dr. Rippon.
Okay. And Ms. Guillory, are you satisfied with your attorney?
Yes, sir.
Okay, Ms. Guillory, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is 129 days time served for both sides to retire to the States.
Okay, Ms. Guillory, the state is offering that you serve 129 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you have already served 129 days in jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. What that means is you will not have to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Guillory, do you understand the state's offer? Do you understand the state's offer?
You understand what they're offering you? The time served, the 129 days credit for time served, which means you're finished with this case.
Yes, sir.
And do you accept it?
Yes, sir.
Okay, Ms. Guillory, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Guillory, you're gonna stand next to the bailiff and follow her direction. Once you finish following her direction, you'll be free to follow the bailiff. You have a blessed day. And Mr. Faggot, you're free to go,
Thank you.
and you have a blessed day.
I didn't have to see anybody back.
interests, such as the interest in security, to ensure that the defendant get a fair trial, and to prevent the disclosure of non-public information. And Ms. Provo, are you requesting at this time that this portion in here be closed to the public so that to prevent the disclosure of non-public information?
Yes, Your Honor.
The court finds that the party seeking to closure has advanced an overriding interest that is likely to be prejudiced to her client. The state or the court has considered other reasonable alternatives. The court finds that the request is no broader than necessary to protect his interests, and the court make these findings, and at this time, this portion of the hearing will be closed to the public. Hold on, wait,
Hold
hold on.
and stop fucking cussing.
Okay.
That woman right there?
Mr.
This
Adams,
is a professional place.
Mr. Adams.
Hey, I'm here. Yeah, yes,
Okay.
I signed up.
Okay, but now, Mr. Adams, before you
Already.
get started, we conducting an informal inquiry on Adam Benjamin Grill on the previous case.
I met with him yesterday.
I know. What I'm saying is the previous case, the court conducted an informal inquiry. He has a new case, and so the court is going to conduct an informal inquiry on this case as well. And are you requesting that this portion of the hearing be closed to the public to prevent the disclosure of non-public information?
Yes, I do.
Okay, the court finds that the party seeking the closure has advanced an overriding interest that is likely to be prejudiced to his client. The court finds that this request is no broader than necessary to protect those interests. And the court further finds that the court has considered other reasonable alternatives, and at this time, this portion of the hearing will be closed to the general public.